But I want to go into the last point to wind this down, which is that the guardrails that existed during Trump's first presidential run no longer exist in 2024. The laws and the accountability to the president for being pursued for criminal acts no longer exist. And Donald Trump may be entering an office without guardrails, with much fewer guardrails than 2020. He has learned his lesson. He will more easily be able to enact whatever he wants to do with election fraud, with entrenching his power, with opening, fraudulent investigations, with essentially assassinating the reputation of American citizens, or assassinating American citizens themselves, as we'll get into with this Supreme Court ruling. But due to the Supreme Court ruling of Trump versus the United States, any guardrails for the president, almost all guardrails, I'll say, for the president committing criminal acts are now gone. So think about that. Think about what Trump did in 2020, and now think about that without any of the, safety nets that were able to at least quell his Stop the Steal movement and all the other fraudulent shit. So in 2023, Trump was indicted for the conspiracy, and this is the Supreme Court ruling of Trump versus the United States. So in 2023, Trump was indicted for conspiracy to overturn the 2020 election by knowingly spreading false claims of election fraud to obstruct the certification of the election results. The Supreme Court's response was, no, Trump did not obstruct the election process. That, Trump didn't do anything wrong. The Supreme Court actually said, under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. And he is entitled at least presumptive immunity from prosecutions for his official acts. There is no immunity for unofficial acts. So essentially what that means is when Trump was indicted for conspiracy to try to overturn the election, the Supreme Court said, well, we're not going to say he didn't try to obstruct the election process, but because the president is committing a crime in a presidential official manner, he can't be held accountable. That was the Supreme Court's ruling. Not everyone on the Supreme Court voted for this. There were dissidents for this ruling, which we'll get into. But some other background information is Jack Smith, the special counsel for the U.S. Department of Justice, just re-indicted Trump in October on the grounds that the election fraud falls outside of the official acts of the president. So the Supreme Court said, all the shit that Donald Trump's being accused of with the election fraud, with January 6th, and inciting a violent insurrection, that falls under presidential official duties. So he is immune for those official acts. And we'll get into what that means. Jack Smith says, no, those are not official acts because President Trump did that as a candidate running for president. And the office of the president does not, the office of the president is indifferent to who occupies that role next. So anything that Trump took as a candidate, an electoral candidate, is not official presidential conduct. So therefore, he should not be immune to election fraud, tampering, and interfering with the DOJ and inciting a violent insurrection. So Trump was re-indicted on the grounds that election fraud falls outside of official acts of the president. We'll see what happens. But the current Supreme Court ruling still has massive implications on what future presidents can get away with. So this is what Justice Sotomayor on Trump versus this is what Justice Sotomayor has to say on the Trump versus U.S. ruling, who was a dissenting judge on this, this ruling. She did not agree. She did not vote positively for this ruling. Justice Sotomayor says the court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. The new official acts immunity now lies like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The president is the most powerful person in the country and possibly the world. When he uses his official powers in any way, under the majorities, he will now be insulated from criminal protection and he will now be insulated from criminal prosecution. Order the Navy's SEAL Team 6 to assassinate a political rival? Immune. Organize a military coup to hold on to power? Immune. Take a bribe in exchange for a pardon? Immune. Immune, immune, immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. And that is Justice Sotomayor, a dissenting judge. So, for example, with the Supreme Court essentially saying that no official actions of the president can be criminally prosecuted, that you're immune from all core official actions. One of the core official actions of the president, presumably, is commanding the military, being the head of the executive branch. Any action associated with that or on the periphery, according to this ruling, the president would have absolute immunity from. So the president would, in theory, be immune for, like Sotomayor says, using Navy SEAL Team 6 to assassinate a political rival. Kamala Harris, not Kamala, because Trump's not president now, but like whoever, in theory tries to go against Trump if he wins office in 2024, the president in theory would be immune from using the American military forces on political rivals or even against Americans on our own soil, because that falls under the official powers of the president. Also, the DOJ is an official function of the president. The president, in theory, could be immune from creating sham investigations and fabricating evidence like Trump has already proven he will do if given the opportunity with election fraud, with no basis for claiming such. There is, as part of the Supreme Court vs. Trump Act, there is tons of guidance on what defines an official act of the president in the Supreme Court ruling, and little to no guidance on what defines an unofficial act. This is a quote from the ruling. The immunity the court has recognized, therefore, extends to the outer perimeter of the president's official responsibilities, covering actions so as long as they are not manifestly or palpably beyond his authority. That is the vaguest shit I've ever heard. It is so unclear. What does it mean? The outer perimeter never gets defined in this ruling. Unofficial acts are never clearly defined. It's just that like an unofficial act is defined by the space that official act doesn't occupy, but official act is defined as anything that extends to the outer perimeter of the president's official responsibilities, but the outer perimeter is never defined. So this whole ruling is so loosely drawn out that you could make a case for essentially anything the president does as being an official act, which he would therefore be immune from. Another quote from the ruling, in dividing official from unofficial conduct, courts may not inquire into the president's motives. Such a, quote, highly intrusive inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on mere allegation of improper purpose. Nor may courts deem an action unofficial merely because it alleges nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. So in theory, this would protect any future president from facing charges of election interference, which Trump has already proven that he will go through any lengths to interfere in future elections. Justice Sotomayor says, quote, the main takeaway of today's decision is that all the president's official acts defined without regard to motive or intent are entitled to immunity that is, quote, at least presumptive and quite possibly, quote, absolute. Whenever the president wields the enormous power of his office, the majority says the criminal law, at least presumptively, cannot touch him. The official acts immunity has, quote, no firm grounding in constitutional text, history, or precedent, Indeed, those standard grounds for constitutional decision-making all point in the opposite direction. No matter how you look at it, the majority official acts immunity is utterly indefensible. And I think she's exactly right, because over the last 250 years, presidents have largely assumed that they could be held criminally liable for at least some of their conduct. This decision comes out and says explicitly in clear language that presidents are immune from nearly all criminal action, and unofficial acts are not defined at all. There's no definition for unofficial acts. So you can make an argument that everything the president does, almost anything a president does, could fall under official action, which is obviously, incredibly dangerous. Justice Jackson, another dissenting judge, says, to fully appreciate the oddity of making the criminal immunity determination turn on the character of the president's responsibilities, consider what the majority says is one of the president's conclusive and preclusive prerogatives: the president's power to remove those who wield executive power on his behalf. So the president is allowed to remove people in power in the executive branch. While the president may have the authority to decide to remove the attorney general, for example, the question here is whether the president has the option to remove the attorney general by, say, poisoning him to death. Put another way, the issue here is not whether the president has exclusive removal power, but whether a generally applicable criminal law prohibiting murder can restrict how the president exercises that authority. So in theory, this would give the president immunity from poisoning his cabinet because removing those in power is a quote-unquote official presidential action, which is insane. That anything that is official or on the outer perimeter of being official, which certainly removing people from the executive branch is, technically, if you poison someone in the executive branch, you're removing them. Are you immune from that action as president? According to this ruling, yeah, you would be. You would be immune from poisoning people in your own cabinet. Another thing to note about this decision is that the judgment on presidential immunity only argues one side. This whole judgment is saying that the president should have immunity when it comes to core powers so that he doesn't have fear to act boldly, so that you don't restrict the president in any way from acting. You don't want him to have any thoughts in the back of his mind that, I could be prosecuted for this if I'm acting on behalf of the American people. But the other side the other side of the argument is, shouldn't the president have some reservations about certain actions? Shouldn't the president be hesitant about certain things, like war crimes, like bribery, like ordering assassinations? These should be things that the president is reserved about, that you're not just, absolutely immune from, that you should have to think about doing these things because they matter. They are huge, they have huge implications for not just people in the United States, but also, citizens of the world, people around the world that are, under the superpower of the United States. Some commentators, and I like this analogy, some commentators have outlined the decision like this: the office of the president is like a gun. You have the right to get elected to use that gun however you want. Your motives and purpose for using that gun are irrelevant. Criminal law no longer applies to your use of that gun under this ruling. Criminal law does not apply to how you use that gun under this ruling.